as question number 6 of Hindu Adoption and Maintenance Act 1956 is a problem, and that is discuss the requisites of a valid adoption under the act. And the very problem here is a Hindu male of 25 years of age adopted a daughter of 14 years of age. Discuss the validity of such adoption. Is it makes any difference if the adopted child is a son of 14 years of age? Explain. So, this very problem comes under the provisions of section 11, which is regarding the very conditions for a valid adoption. So, under section 11, as under subsections, it provides if the adoption is by a male and the person to be adopted is a female, the adoptive father is at least 21 years older than the person to be adopted. And another subsection expresses that if the adoption is by a female and the person to be adopted is a male, the adoptive mother is at least 21 years older than the person to be adopted. So, according to these subsections, as the problem is that Hindu male A, he is have the age of 25 years of, and he is adopting a daughter of 14 years of age. So this adoption is not coming within the very provisions of the subsection of section 11. As per, we don't find exactly the 21 years of age gap between the adoptive Hindu male and the daughter who is to be adopted. So this adoption is invalid. And if the very Hindu male of 25 years of age is adopting a child and who is a son of 14 years of age, then such adoption would be valid, as the very male is a Hindu of 25 years of age, and that child who is to be adopted is also a male, a son of 14 years of age. So, there would be no requirement of 21 years of age gap as per the provisions under section 11 regarding the conditions for a valid adoption. So, if it is a son to be adopted by the male Hindu of 25 years age and that son to be adopted of 14 years of age, then it would be valid, as it is not violating the very provisions of those subsections of section 11. And another important question is that question number 7, which deals with adoption is a legal fiction and doctrine of relation back is a religious fiction. Elucidated these statements and this very provision of the doctrine of relation back is falling under section 12 of the act, and which is dealing with the legal effects of adoption. And as the very doctrine of relation back express that this very doctrine placed the adopted son back from the date of the death of the husband of the adoptive widow or mother in the adoptive family, so as to create all the rights and privileges in him retrospectively as a preferential heir. He could divest his mother of the property inherited by her from her deceased husband. Now, under this act, the adopted child is deemed to have come into existence in the adoptive family from the date of his actual adoption and not from a back date. So, this is the very difference between adoption as a legal fiction and the very doctrine of relation back is a religious fiction. And relating to that, we already have discussed certain important leading cases delivered by the Supreme Court. One is Punita Bhali versus Ramalingam in 1970, and another was D.S. Aglavi versus P.M. Aglavi in 1988 by the Supreme Court. So also Dinaji versus Dadiji in 1990. The judgment delivered by Supreme Court. So also we found the most important aspect of this section is that the adopted child could not marry anyone from the family he or she was taken in adoption, and also in the family to which he or she was adopted. This principle of subpoena and degrees of prohibited relationship given and all it governed by this section. And another important question, that is the ninth one. What are the effects and results of a valid adoption of a child before and after the commencement of the Hindu Adoption Act? So, regarding that, we found under the very section, that is section 20, which provide that the parents are liable to maintain their minor children. It includes both legitimate and illegitimate children. The children on acquiring majority or capacity to maintain themselves brings their liability to one hand. Further, unmarried daughters can claim maintenance subject to the conditions that they are unable to maintain themselves by own separate earnings and property. When a daughter becomes widow without having any earnings and property out of her deceased husband, can also claim maintenance from her parents. So, in that connection, we have already discussed certain important leading cases, and now we'll discuss the another important question, that is the question number 8. discuss the provisions relating to maintenance of wife under Hindu Adoption and Maintenance Act 1956. When can she claim separate residence and maintenance? So, regarding that, we found the very provision under section 18 of the Act, which express wife has the right to maintenance and right to separate residence. This is no more a moral obligation, a legal obligation for the husband and a personal liability for him. This right to a wife exists for the whole span of her marital life. She will lose this right in the circumstances if she converts to any other religion, or if she becomes unchaste, or if she resides separately without any reasonable justification, or if she lives separately under a compromise. Wives waives her right to maintenance. This right to maintenance regarding separate residence are provided under certain circumstances, and these are: the husband is, if guilty of desertion and abandons her or neglects her, or husband has treated with cruelty, or if the husband is suffering from leprosy, or if any other wife living with the husband, or if the husband keeps a concubine in the same house, or habitually living with a concubine elsewhere, and if the husband ceases to be a Hindu, or if there is any other ground justifying or living separately. So, these are the grounds under which a wife can claim separate residence and maintenance from her husband as provided under section 18 of the Hindu Adoption and Minority Act 1956.